take to you.
We're going to talk about the cases that were decided by the United States Supreme Court, the Appellate Division, and the New Jersey Supreme Court up through and including August the 9th of 2016. There have been no additional search and seizure cases since that time. There was a case yesterday, Boykins. I have not had a chance to read it, so I don't know if it's relevant to our discussion. So August the 9th is our cutoff date. And that having been said, let's take it from the top. I wanted to discuss for a few moments exceptions to the exclusionary rule. It's going to be important in the first case we're going to talk about this morning. Just a little bit of background so I can contextualize the legal issues we're going to be discussing. The starting point for our analysis is the 1914 decision of Weeks versus the United States, where the United States Supreme Court held that the Fourth Amendment, at least in federal cases, will not countenance violations of the Fourth Amendment rights of people in our country, and that the solution for giving power to the Fourth Amendment is the suppression of evidence that the police sees in violation of someone's Fourth Amendment rights. Now, there are basically three justifications for this, as outlined by the court in the Weeks case. The first is, as I just said, that the Fourth Amendment itself would be meaningless unless there was some type of sanction for the police at the end of the day, meaning that violating the rights of individuals will not benefit them because the evidence is going to wind up being suppressed. The second is to purify the judiciary. In other words, the judiciary does not have to buy in or become a party to illegal conduct by the executive branch of government in terms of police misconduct when it comes to the Fourth Amendment. And finally, it's intended to have a deterrent effect to kind of dissuade the police from future violations, be it negligent, reckless, or purposeful, in terms of violating the rights of the Fourth Amendment. Fast forward to 1961, Mapp versus Ohio, and the United States Supreme Court now makes the Fourth Amendment applicable to the states through the actions of the 14th Amendment's Due Process Clause. It's very interesting. Joe and I, we're children of the 50s, and when we were very small children, we would sit with our fathers and watch Dragnet, which was in those days, great big popular show. I'm talking about the really old Dragnets, okay? Like the 1950s Dragnets, you remember that, right?
Not
okay.
the Baird 714.
No. Ben Alexander. By the way, did you know that Ben Alexander is one of the most famous movies ever made? Did you guys know this? He was the co-star in All Quiet on the Western Front, the 1932 movie. With Lou Ayres, right? He's in that movie. He's one of the soldiers. Nobody does that kind of junk. Anyway. What's that?
I know it now.
Well, all right. So, in any event, it's fun to watch the show because you see them like kicking in doors and doing all these crazy searches, stuff you can never get away with now. But there was no Mapp versus Ohio in those days. Fourth Amendment didn't apply to the states in that era. So it's just kind of funny to watch that stuff happen. But the same philosophy now applies to the states as applied to the federal government from the 1914 decision in Weeks. Now, notwithstanding the reasons and justifications for the exclusionary rule, there are occasions when, notwithstanding a palpable, obvious, serious violation of the defendant's Fourth Amendment rights, evidence will not get suppressed, okay? And the reason for that is because it won't serve any useful purpose. It won't deter future police conduct. It's not going to impact on terms of purifying the judiciary. In other words, none of the public policy reasons for having an exclusionary rule in the first place will be served by suppressing the evidence. Now, there are three situations where this comes up. And I will tell you, in New Jersey, we follow these same three exceptions. They're essentially coextensive with what the United States Supreme Court has done. The one thing I want you to all know, though, is that the burden of proof on two of the three of these is enhanced. So if you get into a fight with the prosecutor's office on one of these things, it's important to understand that when the prosecutor is putting his case on, he has an enhanced burden of proof in these types of motions to suppress, and that burden is proof by clear and convincing evidence. It's not the normal civil standard that you have in these types of cases. All right? So let's get into these three exceptions. The first of, and here they are, the inevitable discovery doctrine, the independent source rule, and the attenuation doctrine. All right? So here's the inevitable discovery doctrine. This came about in a case called Brewer versus Williams, and it went back to the Supreme Court twice. The second time, I think it's captioned Nix versus Williams, N-I-X. You all studied this case in law school. This is known as the Christian burial case. It's really a Fifth Amendment case more than a Fourth Amendment case, involving a defendant who was arrested for having been suspected of murdering a very small child. And the police had him in custody. The guy had an attorney, and the whole idea was they were going to transport this guy from the place where he had been arrested to the county jail, which was some far distance away. The attorney who was going to follow them in a car, follow the police, said, "Listen, I don't want you guys talking to my client. He wants to remain silent. Don't interview him." And the police say, "Oh, okay, no problem." So away they go in this caravan. And the police immediately go to work on the guy. Not talking to him directly, but talking to each other. "Yeah, looks like we're going to have some snow tonight. Yeah, big snow. We're going to get a couple feet. Yeah, it's a shame, that they've never recovered the body of that little kid, little girl. And she's out there in the woods someplace, and she'll be covered over with all this snow, and they might not find her body until next spring or summer, and by then the animals will have been at it, and she's just going to be deprived of a Christian burial as a result of this. Yeah, you want the family to have a Christian burial for her to say goodbye. They're really working on the guy because they knew he was a nut. They knew that they could prey on him that way. So, of course, the guy, after a half hour of listening to this Christian burial stuff, indicates to the police he can't stand anymore. And I said, "I'll tell you where the body is," okay? Which is just devastating evidence at trial. So he winds up getting convicted. And the takeaway from all this is, yes, they violated his Fifth Amendment rights. No doubt about it, okay? However, what is the point of suppressing the statement, okay? Yes, it helped the cops find the body. But the reality is, the cops would have found the body anyway. All he did was speed up the process. They had search teams going out looking for this little girl around the clock, hound dogs and everything else. They were going to find her at some point. He just, all he did was make it happen faster. So this is the genesis of the inevitable discovery doctrine. If you have a situation where the cops are going to find the evidence anyway as a result of normal investigative techniques, then there's no point in suppressing the evidence, notwithstanding the fact that there's a violation in the next case of the Fifth Amendment and the normal case of the Fourth Amendment. The New Jersey iteration of this, some of you old-timers will remember the case of Dr. Sugar. I think he went to the Supreme Court 3 times. In the Dr. Sugar case, again, kind of a Fifth Amendment issue where he had buried his wife in the backyard, which is not a bad idea when you stop to think about it. And then the police were working on the case, and they intercepted and kind of eavesdropped on conversations between him and his attorney, during which he revealed information about where he had buried the body, and the police were able to utilize that information to find it. So here are the 3 elements. I think I have the citation for Dr. Sugar on here too. Proper, normal, specific investigative procedures would have been pursued in order to complete the investigation. 2, under all the surrounding relevant circumstances, the pursuit of those procedures would have inevitably resulted in the discovery of the evidence. And 3, the discovery of the evidence through the use of such procedures would have occurred wholly independent of the discovery of such evidence by unlawful means. Okay? This is one of those instances where if the state is going to use inevitable discovery, they have to have this enhanced burden of proof by clear and convincing evidence. But Sugar case, again, you keep that's the New Jersey equivalent. And the Sugar case is the one where they ascribe the enhanced burden of proof. Okay? Our independent source, I'm disagreeing with myself on this case. I have State versus Hunt as the New Jersey main case on it, which is true. The best case dealing with this is a Supreme Court decision called State versus Holland, like the country. That's become the seminal collateral source, independent source, or collateral source, same thing, case in New Jersey. So here we go. Source for this exception is the 1920 decision in Silverthorne Lumber versus United States, where the justice held that suppressing is not necessary when the information leading to the discovery of the evidence is obtained from an independent source. In other words, yes, the cops violated his rights, but what led into the evidence came from something else that had nothing to do with the Fourth Amendment violation, okay? Supreme Court adopted this rule under Article 1, Paragraph 7 of our state constitution in State versus Hunt. This Hunt case we're going to be coming back to a couple times today because it's in play as a result of some additional case law in New Jersey. This is just for context purposes. So the three elements on the current version of this exception. The state must demonstrate probable cause existed to conduct the challenge search without the unlawfully obtained information. It must make that showing by relying on factors that are wholly independent from the knowledge, evidence, or other information acquired as a result of the prior illegal search. 2, the state must demonstrate in accordance with an elevated standard of proof, clear and convincing evidence, that police would have sought a warrant without the tainted knowledge or evidence that they had previously acquired or reviewed. And regardless of the strength of their proofs under the first and second prongs, prosecutors must demonstrate by the same enhanced standard that the initial impermissible search was not the product of flagrant police misconduct. We have a case that's going to be coming up this morning that will give you a perfect example of the collateral source rule. Okay, it's absolutely perfect. It deals with another legal issue, but when we get to it, I'll show it to you. It'll make a lot more sense. All right, remember, this is the second one where you have this enhanced burden. Now, the attenuation doctrine is the one that's going to be the subject of our Supreme Court case this morning. This one does not require any type of enhanced burden of proof. So the normal civil standard is in play here. Exception first announced by the court in 1975 in Brown versus Illinois. Under the doctrine, the evidence will be admissible when the connection between the unconstitutional police conduct and the seized evidence is remote or has been interrupted by some intervening circumstance, so that the interest protected by the constitutional guarantee that has been violated would not be served by suppression of the evidence obtained. The attenuation will be examined from the perspective as to whether the connection between law enforcement misconduct and the discovery of the evidence has become sufficiently attenuated as to remove the taint of illegal conduct by the police. Okay? Three elements to this. The first is temporal. How much time has gone by between the time the cops violated the guy's Fourth Amendment rights and the time the cops found the evidence? Now, obviously, the more time that goes by, the more attenuated it's going to be in a temporal sense, and that militates in favor of the police. By the same token, if the cops find the evidence really fast after violating the guy's Fourth Amendment rights, that goes to the benefit of the defendant, okay? Because there's really very little attenuation under those circumstances, at least from a temporal standpoint. Second issue, the presence of intervening circumstances that led to the discovery of the evidence. Yikes. And you're going to see momentarily this has an enormous impact on the court. Something else happened that led the police to find the evidence that's kind of independent from the violation of the individual's rights. And finally, purpose and flagrancy of police misconduct. Is the discovery of this evidence a result of an isolated act of the police purposely, knowingly, or recklessly violating the defendant's Fourth Amendment rights? Or is this part of an ongoing pattern of police misconduct that they're doing constantly, all the time, over and over and over again, okay? Because if it's that, it doesn't serve any useful purpose to avoid suppressing the evidence. You have to deter the police from this type of misconduct. Now, having said that, let's get into our case, which is Utah versus Strife. And I have to tell you, and Joe, please, if you disagree with me on anything, I don't want to put words in your mouth, but you straighten me out if you think I'm off base here, all right? I don't think Utah versus Strife brings anything to the table at all, okay? It doesn't advance the law. It is a humdrum decision. It's really on all fours with Brown versus Illinois. It doesn't add anything new to the law at all. It's just a restatement of this of attenuation doctrine, okay? There's nothing special about that. So we'll talk about the substance of it and things of that nature. But I'm telling you, there's a possibility of this being a landmark decision, okay? Going down in history. And this is the reason we're going to talk about it today. And it has nothing to do with the substantive law that comes out of it. The significance of this case is in the dissent by Justice Sotomayor. Do you agree with me, Joe, or do you think I'm overstating the case?
No, you're right that this is just another recitation of the rule of law, but that Sotomayor's dissent, Sotomayor coming from a somewhat common background, a street kind of background,
right.
She came at this from almost a sociological point of view, pointing out not just the law, but the circumstances in which these incidents occur and the impact it has on people.
Are you in a position to talk about that in a couple seconds, Joe?
I will. How many seconds?
One thing I wanted to share with you is, look, you can't get any more vote. When you go to the bullpen, you're calling in for the left-hander, you want Justice Ginsburg, right? I mean, let's face it. You can't get a more left-leaning justice on the Supreme Court than her. But even she would not join Justice Sotomayor's, the portion of the dissent we're going to talk about. Justice Sotomayor is just so far off the reservation, and which is what is going to make this dissent over the years. We have the advantage of looking back on this 5, 10, 15, 20, 30 years from now. It'll be curious to see how her dissent is regarded. Let's get into the substance of the case. This being Utah, you can imagine, I'm just going to tell you, everybody in this case is Caucasian, and that's going to be significant when we talk about the dissent in the case, all right, that everybody's white in the case. Utah police are looking at a house where there's been a lot of activity in the sense of people pulling up to the house, getting out of cars, going into the house, staying there for a couple seconds, coming out, and then driving away. Now, the people are in there for a short period of time, way too short to be engaged in sexual activity. So the only thing the police can figure out, there must be some type of drug transactions taking place inside this house. The evidence they have to suggest that is none. They just have a hunch, okay, because they're police and that's what they do. They have instincts and they have hunches, and every once in a while they have evidence. But in this case, they don't have any evidence. They just have hunches. They see Mr. Strife approach the house one day on foot. He goes in, stays there for a few seconds, and within 4 or 5 minutes comes out of the house and starts walking away. The police say, okay, there's no doubt in our minds this was a drug transaction. He has drugs in his possession. We're going to go put a stop to this. So they accost him in a parking lot in the vicinity of this house. Now, right off the bat, everybody has to understand that this was not a field inquiry in the normal sense of when we think of it, where the police walk up to you on the street and start asking you questions in a normal conversational tone. A field inquiry is not a seizure within the meaning of the Fourth Amendment, meaning that the cops have no right to detain you, and you don't have any obligation to stay and talk to the cops. It's a completely voluntary exchange between you and the police. So again, that's not a seizure within the meaning of the Fourth Amendment. This was not that. This was a detention, okay, where the police were holding him for the purpose of either confirming or dispelling whatever suspicions they had, okay? Now, we all know that an investigative detention is certainly permissible under the Fourth Amendment, but it's predicated upon the police having a reasonable and articulable suspicion that the guy's been involved in some type of criminal activity. So what was the reasonable and articulable suspicion that the police had this guy was involved in criminal activity? Answer, none. Zero. They had a guy who went in the house, stayed there for a couple seconds, and left. Their instincts are fine, their hunches are fine, but it doesn't, there's no evidence here. There is no articulable suspicion. So no one in the case is contesting that the detention of this individual violated his Fourth Amendment rights, okay? That's off the table, okay? Nobody's contesting that. The police ask him questions, get his name, run his name NCIC, and who knew he has a warrant, okay, for a parking ticket or something. So now the cops are in business, right? They arrest him, and incident to the arrest, they search him, and then they find the drugs they were looking for, okay? Everybody with me so far? Not all that complicated. The motion to suppress is, hey cops, why are you restraining me in this, and doing this investigative detention in violation of my Fourth Amendment rights? You didn't have any reasonable articulable suspicion to detain me for investigative purposes. Everybody says that that's true, okay? Now watch what happens for the Supreme Court. Here's what they say. We hold the evidence discovered on Strife's person was admissible because the unlawful stop was sufficiently attenuated by the pre-existing arrest warrant. So although they violate his Fourth Amendment rights, they find under the attenuation doctrine, the fact that there was an outstanding warrant for him saves the day here. Although the illegal stop was close in time to Strife's arrest, that consideration is outweighed by two factors supporting the state. The outstanding arrest warrant for Strife's arrest is a critical intervening circumstance that is wholly independent of the illegal stop. Discovery of that warrant broke the causal chain between the unconstitutional stop and the discovery of evidence by compelling the police to arrest Strife. And it is especially significant that there is no evidence of the officer's illegal stop reflected flagrantly unlawful police misconduct. In other words, there's no evidence to suggest this is a pattern that they're engaged in on a widespread basis. The evidence that the police officer seized as part of his search into an arrest is admissible because the discovery of the arrest warrant attenuated the connection between the unlawful stop and the evidence seized from Strife incident to the arrest, okay? Now, this attenuation doctrine is the same in New Jersey as it is here, okay? There's no distinction between the two of them. Joe, can you talk a little bit about Justice Sotomayor, and what does she have to say about all this mess?
Yeah, I'm not going to comment on what Justice Sotomayor says. I'm just going to read you certain passages from her dissent because her words are much more powerful than anything that Bob or I could add to them. Bob talked about, Justice Ginsburg, if you need a lefty, the first one out of the bullpen. You haven't seen her ERA lately, and her whip is just out of control.
She hasn't been the same since Justice Scalia died.
It is funny that, you get the most right-wing member of the Supreme Court and the most left-wing member, Justice Scalia and Justice Ginsburg, and the two of them vacationed every year for weeks on end. There's a photo of them riding elephants in India together. They loved each other personally. They were diametrically opposed, on jurisprudence and philosophically, but they were the best of personal friends. And that is really the best of what our profession should be about. We may disagree with your positions, your legal positions. You may be a conservative, you may be a liberal, whatever it is that you don't like, and you may be. But you also have to view people on a personal level. And if they're friendly and they treat you well and you're friends, you shouldn't let your professional differences or your views of how the law should be interpreted get in the way. And very few of us do.
Joe, I hope you'll forgive me for telling one out-of-school story, but Joe and I had the honor of meeting or spending an evening, so to speak, with Justice Scalia shortly before he died, and watched him give a presentation in Philadelphia. And it was certainly one of the highlights of my legal career, Joe. I dare say it was the same for you.
It was an extraordinary evening, and it resonates in so many other ways other than just what he said. But Justice Scalia is was very, very genial and funny, had a great sense of humor. He was a very practical guy. He just had a view of how to interpret the Constitution that many agree with and many disagree with. But as a person, as an individual, as a speaker, you'd love to have him as a guest at your home because, the conversation is funny and raucous and not censored. He's a very interesting man.
Joe, before you start, I just want to mention a couple little things about Justice Sotomayor. I don't know if you guys remember her hearings before the Senate, her confirmation hearings, but she takes great pride in the fact she grew up basically on the streets of projects in the Bronx. She regards herself as really kind of a rough and tumble street type person. She's very proud of her heritage and felt that the input from a wise Latina would benefit the court and the interest of justice. So a lot of what she's saying here is written from a street level. And Joe mentioned conservatives and I guess progressives, and each side found a lot to like in her dissent. That's really one of the funny things about it. What's it all about, Joey?
Justice Sotomayor begins her dissent thusly. Now remember, this man walked out of a home. The police saw a lot of people going in and out of the home. They suspected that people may be going in and out to buy drugs, but they had no proof of it. So one guy walks out, the cop says, "Come over here, talk to me." And in the process of doing so, the officer calls up and says, "Give me a warrant check on this guy." And next thing you know, he turned out to be a really bad guy. He had forgotten to pay a parking fine, and there had been a bench warrant issued from whatever their local municipal court was. And as a result of that, he then got arrested and searched, and they found drugs on him. The court today holds that the discovery of a warrant for an unpaid parking ticket will forgive a police officer's violation of your Fourth Amendment rights. Now, see that she talks in the second person here, your Second Amendment rights. She says, she doesn't say in the third person, someone's Fourth Amendment rights or a citizen's Fourth Amendment rights. She is talking to you in here, and that's what comes across. The court holds today that the discovery of a warrant for an unpaid parking ticket will forgive a police officer's violation of your Fourth Amendment rights. Do not be soothed by the opinion's technical language. This case allows the police to stop you on the street, demand your identification, and check it for outstanding traffic warrants, even if you are doing nothing wrong. If the officer discovers a warrant for a fine you forgot to pay, courts will now excuse his illegal stop and will admit into evidence anything he happens to find by searching you after arresting you on the warrant. Because the Fourth Amendment should prohibit, not permit, such misconduct, I dissent. So right out of the box, you know where she stands. And of course, when she talks about, demand your identification, how many of us grew up on movies where the Nazis always said, "We want to see your papers. Where are your papers?" And there was always some American soldier who was undercover and knew how to speak German who gets stopped. Moments after Edward Strife, the defendant in this case, walked out of a Salt Lake City home, an officer stopped him, questioned him, and took his identification to run it through a police database. The officer did not suspect that Strife had done anything wrong. Strife just happened to be the first person to leave a house that the officer thought might contain drug activity. It is tempting in a case like this, where illegal conduct by an officer uncovers illegal conduct by a civilian, to forgive the officer. After all, his instincts, although unconstitutional, were correct. But a basic principle lies at the heart of the Fourth Amendment. Two wrongs don't make a right. When lawless police conduct uncovers evidence of lawless civilian conduct, this court has long required later criminal trials to exclude the illegally obtained evidence. For example, if an officer breaks into a home and finds a forged check lying around, that check may not be used to prosecute the homeowner for bank fraud. We would describe the check as the fruit of the poisonous tree. Fruit that must be cast aside includes not only evidence directly found by an illegal search, but also evidence that comes at the exploitation of that illegality. This exclusionary rule removes an incentive for officers to search us without proper justification. It also keeps I love this. It also keeps courts from being made a party to lawless invasion of constitutional rights of citizens by permitting unhindered governmental use of the fruits of such unconstitutional invasions. When courts admit only lawfully obtained evidence, they encourage those who formulate law enforcement policies and the officers who implement them to incorporate Fourth Amendment ideals into their value system. But when courts admit illegally obtained evidence as well, they reward manifest neglect, if not an open defiance of the prohibitions of the Constitution, which is a quote from Weeks. The majority also posits that this officer could not have exploited his illegal conduct because he did not violate the Fourth Amendment on purpose. Rather, he made a good faith mistake, and those are in quotes. Never mind that the officer's sole purpose was to fish for evidence. The majority casts his unconstitutional actions as negligent, and therefore just incapable of being deterred by the exclusionary rule. But the Fourth Amendment does not tolerate an officer's unreasonable searches and seizures just because he didn't know any better. Even officers prone to negligence can learn from courts Even officers prone to negligence can learn from courts that exclude illegally obtained evidence. Indeed, they are perhaps the most in need of an education, whether by the judge's opinion, the prosecutor's future guidance, or an unpaid manual on criminal procedure. If the officers are in doubt about what the law requires, exclusion gives them an incentive to err on the side of constitutional behavior. Writing only for myself and drawing on my professional experiences.
And that's it, by the way, this is significant. When she says writing only for myself, none of the other 8 justices on that court, or the 7 additional justices, would buy into this. Not even Justice Ginsburg.
Right. Okay. There were 2 other, Justice Kagan and Justice Ginsburg, dissented from this, but they did not join her in this part. Writing only for myself and drawing upon my professional experiences, I would add that unlawful stops have severe consequences, much greater than the inconvenience suggested by the name. This court has given officers an array of instruments to probe and examine you. When we condone officers' use of these devices without adequate cause, we give them reason to target pedestrians in an arbitrary manner. We also risk treating members of our communities as second-class citizens. Although many Americans have been stopped for speeding or jaywalking, few may realize how degrading a stop can be when the officer is looking for more. This court has allowed an officer to stop you for whatever reason he wants to, so long as he can point to a pretextual justification after the fact. The justification must provide specific reasons why the officer suspected you were breaking the law, but it may factor in your ethnicity, and citing a U.S. Supreme Court case. It can factor in your ethnicity and where you live and what you are wearing and how you behaved. The officer does not even need to know which law you might have broken, so long as he can later point to any possible infraction, even one that is minor, unrelated, or ambiguous. The officer's control over you does not end with the stop. If the officer chooses, he may handcuff you and take you to jail for doing nothing more than speeding, jaywalking, or driving your pickup truck with your 3-year-old son and 5-year-old daughter without your seatbelt being fastened. At the jail, he can fingerprint you, swab DNA from the inside of your mouth, and force you to shower with a delousing agent while you lift your tongue, hold out your arms, turn around, and lift your genitals. Even if you are innocent, you will now join, hold on to your seats, even if you are innocent, you will now join the 65 million Americans with an arrest record.
And that's just in Bergen County.
And you will experience the civil death of discrimination by employers, landlords, and whoever else conducts a background check against you. This case involves a suspicionless stop, one in which the officer initiated this chain of events without justification. I dissent.
Well, the part that Joe has, because this is a much longer dissent, a lot of this is more akin to a political screed than law. And I think that's why the other justices wouldn't join her. She incorporates the impact this has on black and brown people. They're the ones who are, like, say, for Mayor Giuliani's campaign of what stop and frisk, okay? That's what she's talking about here, all right? And I don't know whether it's been proven whether that was effective or not in terms of cutting back crime. Politicians say it is. I haven't seen any, scientific evidence one way or the other.
A study just came out yesterday on it, and the examining authority said that the stop and frisk had no deterrent value whatsoever, and stopping people for minor crimes hasn't had a deterrent value. And the chief of police responded, really? He says, did you see the drop in crime over the last few years?
Right.
And you tell me it's not related?
Well, I mean, look, there's politics and there's science, and they're two very nice fields, but they have nothing to do with each other, okay? But her concern is the impact, the disparate impact that this has on people of color in the United States. Lower class, substratum, lower type people from a socioeconomic standpoint. Everybody here is white, okay? White people don't get exposed to this as the same as people of color do. And this is her main concern, that the police utilize these types of things. And she'll utilize, either directly or indirectly, a lot of shibboleths that are very common in today's political, socioeconomic culture. So Black Lives Matter, I can't breathe, hands up, don't shoot. All these things are worked into her dissent to greater or lesser degree. Much of the scholarship here has nothing to do with law whatsoever, but rather it's more related to political and sociology type things, all right? She has a point to make, and a lot of people on both sides of the political spectrum, libertarians as well as people who are progressives, agreed with her. So it's controversial. We could do a whole class on it. I just want to point out to everybody that it's out there. We'll come back in 15 years and see what the impact of this has been. All right. Now, I guess, Joe, I'm going to ask you to, because I don't want to say anything that's really legally incorrect, but would you agree with me that the legal issue related to mistake of law as a Fourth Amendment issue is in an enormous state of flux in New Jersey right now?
It's certainly in a state of flux because it has been since 1987 prohibited in New Jersey, but it is back on the table, and some appellate divisions have actually relied upon it, one of which is pending.
Yeah, I meant to ask you about that. Did the Supreme Court ever decide on certification for State versus Sutherland yet?
I did get, after having filed for, there's a particular case, State versus Sutherland, that I'm involved in only on the post-appellate division level, going to the Supreme Court, where the court, both the law division and the appellate division, overturning the municipal court judge's opinion, said that mistake of law is at play. Whereas in Pabuzio, we the Supreme Court said it wasn't, but they're bringing it back in light of a U.S. Supreme Court that was decided in 2014. But the status of the matter is, because we were brought into the case late, we asked for an extra 2 weeks, and we filed a petition for that. We filed our petition for certification, all of that. And yesterday we got a decision. They finally condemned it to 4 months. It was, and they said, oh yeah, we grant your extension of time for the filing.
Okay.
So that's all it is. They've granted our extension of time and our petition for certification.
Okay.
And now it's and this state has already responded to it, and now they're going to decide whether they're going to take it. I don't see how they cannot.
They have to. And you guys will see where we're going with this momentarily. Let me just, and Joe has been involved with this defense, as a drunk driving defense advocate. Joe's been doing this for a long, long time. He's been to this, this is not his first rodeo. What year was State versus Williamson? Around 96?
94.
All right. Joe tried this, for example, in the use of a turn signal, okay, where a police officer effected a motor vehicle stop, which the defendant turned out to be drunk. Joe arguing that the police officer was mistaken on the law because you're not required to use your turn signal unless it could affect other traffic. Police officer thought you had to use it every time you made some type of maneuver. Police are constantly getting confused and misinterpreting the impact of statutes. And when they affect motor vehicle stops based upon a mistaken view of a statute, it's grounds for you filing a motion to suppress because, the stop is not, it's not a reasonable stop if the police officer's mistaken, okay? So, when I tell you things are in a huge state of flux, that leaves you with opportunities as attorneys in here, okay? What I want to do is kind of, and Joe, work with me on this a little bit because you're kind of involved in this up to your ears. I want to kind of analyze it in the following way, because we're fortunate in the sense that we know certain things, and the certain things we don't know. But the things that we don't know, we know that we don't know them. All right? Am I starting to sound like a politician?
There are known knowns. There are things we know we know. We also know there are known unknowns. That is to say, we know there are some things we do not know. But there are also unknown unknowns. The ones we don't know, we don't know.
Everything that guy just says, bullshit. Thank you.
So let's start very, very deliberately. What do we know that is now settled law as of Friday morning in New Jersey, right this second? There is a case. We're going to talk about all these cases in a moment, but I'm going to start off with a case called State versus Scrivener, okay? Scrivener, for your purpose, this is the takeaway, that an unreasonable mistake of law by a police officer cannot justify a motor vehicle stop. Okay? An unreasonable mistake of law by a police officer will not justify a motor vehicle stop in New Jersey, either under the United States Constitution or the state constitution. Both barrels are there. Let me give you the facts of the case. You'll see what I'm talking about. Scrivener involves a police officer, I think it was a Hudson County police officer, who's outside of his vehicle. He sees a car approaching his position in the nighttime. The car has its high beams on. The car passes him, never turns the high beams down. The officer believes that this is a violation of 39-360. He gets in his car, chases the guy down, stops him, and that leads to the recovery of evidence.
Otherwise, it wouldn't be a case.
Right. Now, the officer legitimately believes that's a violation of 39-360. Okay? The Supreme Court looks at the elements of the statute. Okay? What does 39-360 say? It says you have two vehicles, both being operated, that are oncoming to each other. And when they get within 500 feet of each other, they got to shut their high beams down. It's a one-sentence statute. Okay? And the Supreme Court, paraphrasing, says any idiot looking at the statute would be able to figure out what it means.
Well, there was one idiot, apparently, that didn't.
No, two idiots, Joe.
Oh, that's right. That's right.
Because there's a second idiot we have to talk about. A trained police officer should understand that it doesn't apply to pedestrians standing out on the street corner, and it doesn't apply to people who are parked in cars. It has to be two vehicles that are oncoming to each other. So the police officer's misinterpretation of this very, very simple statute is unreasonable. A trained police officer should not, objectively looking at it, should not misinterpret the statute. That being the case, the police officer acted unreasonably here because his interpretation of the statute was an unreasonable interpretation. Therefore, the evidence, because of the stop, was unreasonable. The evidence winds up getting suppressed. Everybody with me? All right, now, be mindful. This is decided both under the state constitution and the United States Constitution. All right? That's the only thing I can tell you about mistake of law that is written in stone. Everything else is in play at this point. Agree?
Well, it's up in the air.
All right. So let's go through it step by step chronologically. We'll see how the law has developed, and I'll give you ideas about how you can advance this in oral argument on the motion to suppress. All right, let's start off with Puzio, Appellate Division, 2005. What do you remember about this case, Joey?
Well, Puzio involved a traffic law that even I didn't understand until I read Puzio, which is this. If you have a commercial vehicle, and I'm going to define that in a second. If you have a commercial vehicle and you have commercial plates on it, you need to have lettering on the side with the name of the company, okay? Officer sees a sports car coming down the road as it goes by him. He says, ooh, commercial plates. I don't see, anything written on the side, Ace Towing Company or Ace Printing Company or something like that, and pulls them over. Turns out that it doesn't actually apply to passenger vehicles. It applies to trucks, vans, and trucks, not to passenger vehicles. So the Puzio court had to decide, what are we going to do here? He pulls this guy over, and maybe it's a difficult law to understand. And they said, well, but we're really not going to reach that because we're going to say the only law that matters is the law, not whether an officer was reasonable in misunderstanding the law. Like, wow, I misunderstood the law, but I don't actually go out and pull people over, for that offense while I'm driving to work in the morning. So it doesn't matter that I misunderstood the law and that following this case I was now educated in it. He misunderstood it, but they said it doesn't matter. Stops are not governed by the officer's conception of the law, their impression or misimpression of the law. It's governed by the law. If it's not the law, then the stop was unreasonable.
Turned out to be intoxicated, so it's a drunk driving case. All right. Interesting to me, the particular vehicle in here, it has an X in the license plate, and that's what tipped the cop off to the fact that it's a commercial vehicle. This passenger automobile was owned by a drugstore, and the legislature has exempted certain passenger automobiles, including those owned by drugstores, because the guy's making delivery of drugs. You have 15 people trying to break into the car while he's out, bringing the aspirin to somebody, to some patient. Okay, so that's the reason why it's, kind of exempt from that. Now, think about the analysis of the Appellate Division in this case, going back to 2005. In New Jersey, the touchstone of the Fourth Amendment, of course, is reasonableness. And we judge the actions of the police on objective reasonableness, okay? Now, when a police officer misinterprets a statute and stops a motor vehicle based upon a law that does not exist, can that be objectively reasonable? The police officer believes it is against the law to play your radio in your car on a Tuesday and stops your car based on that basis and finds drugs or you're intoxicated or whatever. Is it reasonable to allow the police to effect motor vehicle stops when they misinterpret statutes? And the answer by the Appellate Division is no, it's not. Okay? It's not objectively reasonable. Take a look at what they say. Joey, can you read this, please?
The legal justification for the vehicle stop must be objectively grounded. Even under the good faith exception rejected in Novembrino, objective reasonableness is judged through the eyes. Now, this is critical because you're going to see this in later decisions. Is judged through the eyes of a reasonable officer acting in accordance with governing law. To create it, in fact, Justice Sotomayor quotes that in her dissent in Hyen, the opinion that in Sutherland. Creates an exception, judge through the eyes of a reasonable officer acting in accordance with governing law. To create an exception here would defeat the purpose of the exclusionary rule, for it would remove the incentive for police to make certain that they properly understand the law that they are entrusted to enforce and obey. If officers were permitted to stop vehicles where it is objectively determined that there is no legal basis for their action, the potential for abuse of traffic infractions as a pretext for effecting stops seems boundless, and the cost to privacy rights excessive. We cannot countenance an officer's interference with personal liberty based upon an entirely erroneous understanding of the law. The officer had no objectively reasonable basis to support his conclusion that defendant's car was being operated in violation of that statute. As a result, his stop of the vehicle was unlawful, and defendant's motion to suppress should have been granted.
Now, interesting in this case, and when you vet this, you'll see there is no reference at all to any constitution anywhere. The panel does not make a reference to the Article 1, Paragraph 7 of our state constitution. And there is no reference to the Fourth Amendment at all. Now, the second part of this I can explain very easily. You know why there's no reference to the Fourth Amendment in this case? Because in 2005, the United States Supreme Court had never ruled on this discrete issue. They had never had a case where they had to decide whether or not a mistake of law in a traffic case could justify a motor vehicle stop. Okay? Now, why this is important for all of you is that you're going to argue that Puzio is good law until the Supreme Court decides Sutherland. You have a window of opportunity here. And what you will argue is that Puzio expresses the law, and it had to have been decided under the New Jersey Constitution because the United States Supreme Court had not decided the issue at that time. They didn't discuss it until 9 years later in 2014. Everybody with me on this so far?
Hey, Bob, can I just... They're not all going to argue that we have a prosecutor here.
Oh, okay. Joe, call the police immediately. Everybody cool with this, though? All right. So, Puzio, on its face, would seem to say, under the state constitution, it doesn't matter whether the mistake of the police officer was reasonable or unreasonable. If he's wrong, if he's objectively wrong, the stop is no good. Okay? Remember, the Scriven case, the New Jersey Supreme Court says if the officer's understanding of the law is unreasonable, it gets suppressed. In Puzio, it doesn't matter whether it was reasonable or unreasonable. Either the statute, the law either says it or it doesn't say it. Okay? If it doesn't say it, it doesn't make any difference how reasonable the police officer was. It won't justify a motor vehicle stop. Okay? And what you're going to argue is that's what the New Jersey Constitution under Article 1, Paragraph 7 should supply. Now, the next step here is Hine versus North Carolina. I'm happy to tell you that for once this is not a drunk driving case. Hine involved the recovery of distribution amount of drugs. Okay.
Which in North Carolina is like 2 grams of marijuana as opposed to 1.
Joe, I don't remember whether this was a brake light or just a tail light in the case.
Yeah, it's a brake light, and interestingly, in North Carolina, although, you know, federal law requires there to be a brake light on either side of the car, in North Carolina, when you work your way through their laws, and I have to tell you they are a little bit obtuse, it turns out you only need, when you get down to the bottom of it, you only need 1 of those 2 brake lights to be working. And the officer assumed that you needed to have both brake lights on either side working. In New Jersey, you need to have at least 1 on either side working, and that's the issue facing my client in Sutherland if we get before the Supreme Court. But down there, you only need 1 brake light, and the officer thought he needed 2, so he pulled him over.
Now, look, the point Joe's making here is vitally important, okay? If you think about this case, the officer thinks you need to have 2 brake lights, okay? So he effects a motor vehicle stop. Recovers the drugs. The motion to suppress says, wait a minute, North Carolina law doesn't require you have 2 brake lights. 1 brake light is plenty, okay? So the officer was objectively wrong on the law. Okay. Well, the trial court says, well, I've read the statute over. I'm not sure how many brake lights you need, okay? They go to the intermediate appellate court in North Carolina, and the intermediate appellate court says, nah, you don't really need 2 brake lights here. Then they go to the Supreme Court, and the Supreme Court reverses, says, yeah, you do need 2 brake lights here. So even in North Carolina, the courts of appellate authority couldn't agree about what the statute says, okay? Case goes to the United States Supreme Court. And here's what the Supreme Court says. Hey, you know what? We don't really care whether or not you need 1 brake light, 2 brake lights, or 10 brake lights, okay? It's an extremely confusing statute. reasonable people can disagree over what the meaning of the statute is. Let's forget about that for a moment and focus on the Constitution. What is the touchstone of the Fourth Amendment? Reasonableness. The Fourth Amendment requires the police to act reasonably, not perfectly. That being the case, and by the way, you could not have law enforcement acting perfectly. You can't have anything that's perfect in life. All they have to do is act reasonably. Since the limitation of police conduct is to act reasonably, then the Fourth Amendment has to provide some latitude for mistakes by police as long as those are reasonable mistakes. So just as we forgive a reasonable mistake of fact by the police, we now decide that a reasonable mistake of law is also permitted under the Fourth Amendment. Joey, could you read this little quote to everybody from Hyen?
But reasonable people make mistakes of law too. And such mistakes are no less compatible with the concept of reasonable suspicion. Reasonable suspicion arises from the combination of an officer's understanding of the facts and his understanding of the relevant law. The officer may be reasonably mistaken on either ground. Whether the facts turn out to be not what was thought or the law turns out not to be what was thought, the result is the same. The facts are outside the scope of the law. There is no reason under the text of the Fourth Amendment or our precedents why this same result should not be acceptable when reached by way of a reasonable mistake of fact, but not when reached by a similarly reasonable mistake of law.
So now we have a case from the United States Supreme Court. Remember that the Puzio case didn't cite any Constitution. They just come out and say what they say. Now you have the United States Supreme Court coming out and saying, no, a reasonable mistake of law, can justify motor vehicle stop. Exactly the opposite of what the Puzio court says. Well, what does that do for Puzio? All right. Into the mix comes the Joe Rem case of State versus Sutherland. There's no doubt in my mind that the Supreme Court has to accept this now because they've been kind of painted into a corner.
In Scrivener, which only came out, a few months earlier, they said, we're not going to reach this issue, which said, we're not rejecting it out of hand. We don't need to reach it in this case because we're deciding on a lesser issue. So, guys, this is still in play, and we're not going to comment on it.
Joe, my understanding of the facts is, and I see these cars now, the new cars, for taillights, they don't have like one taillight. They have like 14 little bulbs around a taillight on each side. You guys notice that? Just another way of charging you more money and, wasting time. And my understanding is one of the little taillights around his tail was burned out. Is that what happened?
Well, when you say around his tail, I think it was actually the car. But what happened is it had two, if you had a rectangular taillight, instead of it being one, there was a break in the middle, and there was half one brake light, and then beneath it, an inch lower, an identical size brake light. Right. So there was two on either side of the car. We would view them from a distance maybe as one, but there were two separate ones broken up by an inch, just for a design element. Detroit wanting to sell sexier and snazzier cars, and they broke it up by way of a design element.
Right.
Now, the problem is there were, as the cop watches this car go down the road, he realizes that one out of the four taillights isn't working. And there is a statute that says all taillights on the rear of a car, which are required under the law, must be working. So he pulls them over. Now, it turns out that phrase that I just said, all taillights that on the rear of a car that are required, must be working. However, New Jersey law only requires that there be a taillight on the right and a taillight on the left. Nowadays, we also have a third. We amended our law 3 years ago that the overhead light, if it's installed on the car, if it's a new enough car, that must be working too. But we're only focusing on the left and right. You just need a working taillight on the left and a working taillight on the right. He had that. On one side, he actually had a surplus. He had two working on one side. But he met the basic qualifications.
Now, this is critical. The officer's belief that New Jersey law says all your lights have to be working, okay? One view of the statute is, no, that's not what the statute requires. You just have to have one working on the right and one working on the left, which is what this guy had. So now the issue becomes, well, if A, was the officer wrong, and B, if he was wrong, was it reasonable for him to be wrong on this? It's very interesting to me. I don't think that the law division judge could figure out the statute. And the appellate division goes to great lengths to show how confusing antiquated, nuanced, arcane, and just out of date this statute is, okay? I mean, they do everything except talk about, buggy whips in the statute. It's something that was written in the 1920s. It has nothing to do with modern day motor vehicles. It's just something the legislature has been woefully decades and decades behind in terms of updating. Am I overstating the case, Joe, or would you agree?
No, you're not. Look at even the title of the statute. We're not talking about taillights. We're talking about maintenance of lamps. Like there's a little candle in there or something. Maintenance of lamps. That alone tells you when this was pronounced, this law. So it is, I have to tell you, when I read it the first time, we're being recorded, it was obvious to me from the beginning that what this statute meant. I was not confused, and I didn't think it was a difficult statute.
Okay.
And when we turn off the cameras, we'll talk again. So,
look, reasonable people could disagree about what this statute means, okay? But for your purposes, we're not dealing with 39360, a one-sentence statute for, like we had with the high beam lights, okay? We're dealing with an enormously complex, antiquated, arcane, in many cases obsolete statute.
That's your argument.
Yeah, well.
Mr. DAG, thank you.
So, what is the legal significance of this, okay? Remember, the Scrivener case involved a very simple statute. Here we have a very complex statute, exactly like they had in Hyen. Okay? So it seems to me that Hyen is exactly on point, at least from the appellate division's perspective, with the Sutherland case. And isn't that what the appellate division says? That this is nothing more than the Hyen case?
It does. The appellate division, in my opinion, changes New Jersey law, adopts the law pronounced in 2014 in Hyen by the U.S. Supreme Court, and says not just mistake of fact, as Puzio said, it now includes mistake of, as Pitcher said, but is mistake of law, which Puzio said is not applicable to New Jersey law. Now, remember, Puzio is an appellate division case. Sutherland is an appellate division case. Scriven, on the other hand, was a Supreme Court case, which was a 4-4 tie, but because it was a 4-4 tie, the ruling of the appellate division, which happened to be the same ruling in the law division, holds sway. That means it's not overturned. And the appellate division held that mistake of law is not the law in New Jersey now. So Scriven said that, Scriven in ruling 4-4 held that.
Let's take a look at what the Supreme Court says, the appellate division says in the Sutherland case. Remember, this is Joe's case. The appellate panel here is referring to Hyen, the North Carolina case we just talked about, dealing with the taillight, brake light, whatever it was.
Light, yeah.
The court highlighted in Hyen that the reality that an officer may suddenly confront a situation in the field as to which the application of a statute is unclear, however clear may become later. Indeed, the court noted that an officer may have to make a quick decision on the law. Accordingly, the Hyen court concluded that so long as a mistake is objectively reasonable, it may give rise to reasonable suspicion. Now, here's the key. The appellate division of the Superior Court is a single court. It's one court. It has panels associated with it, but it's a single unified court. So you don't have a situation where one panel of the appellate division is authorized to overturn another. They're all the same. So what the way to finesse this panel says, given the well-reasoned holding in Hyen, the United States Supreme Court's decision, we express doubts as to the continuing vitality of the Puzio decision from 2005. All right?
They did more than express doubts. They completely changed the law. Their holding was completely at odds with what another panel had said in the past, and which the Supreme Court had never contradicted.
Okay. So the issue now becomes the following. We already know that an unreasonable mistake of law in New Jersey will not justify a motor vehicle stop, okay? How about, though, if the cops make a reasonable mistake of law? Will that justify a motor vehicle stop or not? Okay? That issue could have been decided by the Supreme Court in Scriven, but they ducked the issue, and I think they're going to use the Sutherland case to decide it. Here's the Scriven case. Now remember, in Scriven, we're talking about the two cars coming at each other, not turning their high beams down.
Officer standing by the side of the road.
We hold that the trial court and the appellate division properly concluded that the motor vehicle stop violated the federal and state constitution. The language of the high beam statute is unambiguous. Drivers are required to dim their high beams only when approaching an oncoming vehicle. Neither a car parked on a perpendicular street nor an on-foot police officer count as an oncoming vehicle. This case does not involve a reasonable mistake of law by a police officer. We therefore need not address whether such a reasonable mistake would require suppression of the evidence under the New Jersey Constitution. That's your case. That should say Joe Rem, okay? Because the officer did not have a reasonable and articulable suspicion or community caretaking basis to stop the vehicle in which the defendant was a passenger, we affirm the judgment of the appellate division holding the trial court suppression of the evidence. Because he determined his mistake was not objectively reasonable, we will not address the issue dealt with in Hine versus North Carolina. That's going to be your case, okay?
Yes, it is.
All right. Now, it's interesting, and I think your strongest arguments, Joe, is this, that what you're trying to set up here basically is an untenable situation where judges will have to decide these mistake of law cases based upon the complexity, unless they grant your position, the complexity of statutes. You're going to have the judge going to say, well, that's a very simple statute. Any police officer should have known what that says. It's unreasonable, and we're going to suppress the evidence. If the statute is complex, like it was in the Sutherland case or in Hine, well, reasonable people can disagree, so the officer's mistake was reasonable because it's a complicated statute. But you have judges who are making decisions about the complexity of a statute as opposed to, there's no standard for people to grant. And I think you've got to argue that at the Supreme Court, Joe, saying you're setting up an untenable test that nobody's going to be able to implement.
Yeah, well, you should know that in Hine, although the U.S. Supreme Court said that the statute was so complicated that it was reasonable to misunderstand it, they didn't set up any standards or guidelines for evaluating whether something was too complicated to understand. And that leads to this. If you're driving down the roadway, you not only have to operate your car in accordance with what you know to be the law, you also have to take into account what an officer's mischaracterization, misunderstanding, or misconception of the law is, because that will also guide whether or not you will be pulled over and may be cited for something. So you not only have to be guided by the law, you have to speculate on all the ways an officer could misconstrue your driving and worry about that as well. And that's not any way to run a country. It's not any way to enforce traffic laws.
I think you're going to argue that, Joe, that we should go back to the standard for Puzio, which was, by the way, perfectly great for the 9 years that it was around. Nobody had any problem with it. It's very simple to understand, okay? If the officer makes a mistake, doesn't matter whether it's objectively reasonable or not, the evidence gets suppressed because it's not objectively reasonable to allow the police to effect a motor vehicle stop on something that's not the law in New Jersey. And
we should actually, Bob.
You agree that's your argument?
Well, that's exactly what my argument is going to be. It's easier for officers to enforce the law because if they find out it's wrong, well, then the ticket goes out. It's easier for courts to do it, and it's easy for the motoring public to understand what's required of them and not required of them.
So all they have to do is say that we underscore that Puzio is the law, and we're interpreting it strictly under the New Jersey Constitution, Article 1, Paragraph 7, and that solves the problem. Again, the world did not come to an end from 2005 to 2014, all right?
It's so occasionally we're going to trip across somebody that has a gun or drugs in the car, and they're going to, because the constable blundered, the defendant will run free. Yeah, that's true. That's going to happen. But is getting that one person with those drugs or that gun, let's face it, it's not like that's the sole purpose on our highways, and we've now stopped all crime by arresting this person. How many people are driving past here, as we've been here today, with illegal guns or drugs in their car? You and I, we couldn't begin to count them. So it's not like we're ending crime. Do we really want to sacrifice the future of our Constitution and our civil liberties in order to convict one person? Is that what this is about? You remember, all of this goes back, everything we're talking about here goes all the way back to 1789 when our Assembly and our Senate passed amendments to the Constitution and said the only searches that are prohibited are those that are unreasonable. A uniquely wise choice of words, because what is unreasonable will be interpreted by the culture and the times of society. And over years, certainly our view of privacy has changed over the years. Twitter and Instagram and people posting photos of themselves in various poses on the internet, that would have been unthinkable, 100 years ago when women couldn't go to the beach, if their ankles were exposed. They had to wear practically tank suits. And nowadays, women can wear, and men can wear much more immodest suits, and that's considered normal. No one thinks twice about it. Societies change, mores change, cultures change, but because they use the word unreasonable, so does the definition of how we interpret the law and apply our Constitution, because that's a flexible term that accords itself to each and every passing generation, and we shouldn't abandon that flexibility.
Good luck with the case, Joey. Let's get into drunk driving. And Birchfield versus North Dakota is the seminal case on a brand new issue that this was decided in the last week of the court's term. I want to give you the main takeaway on this first, and then we're going to get into some outside-the-box thinking that you can utilize this case to your advantage in New Jersey. Let's talk about Birchfield versus North Dakota. Now, this is the main takeaway for all of you in this case. The issue involves the legality of taking A, a blood sample, and or B, a breath sample from a person who has been arrested for drunk driving. And the justification for the taking of that evidence from the body of these individuals is a search incident to an arrest, okay? Does the search incident to an arrest exception to the warrant requirement justify that? Now, the starting point of our analysis should be the search incident to an arrest exception to the warrant requirement. I'll give you 3 words on that. It is categorical. There's no probable cause or anything else that's related to it. When the police effect a lawful arrest, they are categorically permitted to conduct a search of the person that has been arrested. There are 3 justifications for the search. A, most importantly, remove weapons from this individual that can be utilized to effect an escape or harm the police officer. B, not so important, but it's in there, recover implements of escape, so handcuff keys and things of that nature. And finally, C, recover evidence in possession of the defendant's been arrested that he or she may otherwise discard or hide, okay? Now, this exception to the warrant requirement pre-existed the Bill of Rights. It's something that goes back 1,000 years, all right? And there's no evidence to suggest that the Constitution intended to change this in any way, shape, or form. It's just something that's developed as part of the common law, now protected by the Fourth Amendment, okay? Now let's break this down into its component parts. Let's talk about the taking of blood from a living human being who's been arrested for drunk driving. The first discussion of this that I am aware of occurred in the 1966 case of Schmerber versus California. And the state argued in Schmerber that they have a categorical right to take blood out of the person who's been arrested for drunk driving as a search incident to an arrest. And the Supreme Court rejected that argument at the time and held that searches for evidence beneath the surface of the body, that's their language in Schmerber, beneath the surface of the body, are not permitted as a part of a search incident to an arrest because of the intrusive nature of going beneath someone's skin to get evidence out. So you would think that that would be the end of it. I mean, it was pretty clear what they were saying. The same issue was brought up again in 2013 in the McNeely decision. And once again, the state argues that they have a categorical right to take blood evidence from an individual who's been arrested for drunk driving. The United States Supreme Court holding no, there is no categorical right to take blood from somebody who's been arrested for drunk driving. You can get the blood in basically one of 3 ways, and they only discussed 2 of the ways in McNeely. A, get a search warrant, or B, if you have exigent circumstances that make it impractical or impossible to get a warrant, you can take it under the exigent circumstances exception to the warrant requirement, okay? They don't talk about consent in the case, so I don't want to throw something in that's not there. But again, the court rejected now for the second time the idea that you could utilize search incident to an arrest to take blood out of a living human being. The matter has finally been put to bed very specifically in Birchfield, okay? And the takeaway, the first thing you guys should get is that it is unconstitutional to take a blood sample from a person who's been arrested for drunk driving, okay? Not only is it unconstitutional, but the Supreme Court strikes down any statute in the United States which requires people to give a blood sample after they've been arrested for drunk driving, okay? They're all unconstitutional. So for the third time now, the court has ruled that the search incident to arrest exception to the warrant requirement does not apply to the taking of blood from a person. Why? It's intrusive, it's inconvenient, there's a little bit of pain associated with it, And the evidence that you're taking from this person has a lot of other additional uses, which include, you get the guy's entire genome from a blood sample. Okay? Now, what about breath? Contrast breath. Breath has one limited purpose, and that's just to find out what your blood alcohol level is. There's no additional utility to a breath sample. Unlike having a needle stuck in you and all the other inconveniences associated with that, the breath is quick, easy, can be done by a moderately trained police officer. It's fast and very, very minor intrusion on your privacy by giving a breath sample. Given the minor nature of this type of intrusion, the court found that requiring individuals to give a breath sample incident to an arrest is legal. It's constitutional. The Fourth Amendment will countenance that. They analogized it somewhat to the taking of DNA samples through the use of a buccal swab for people who've been arrested. Many states have statutes that require people to give a buccal swab at the time they've been arrested in order to get samples of their DNA. And the Supreme Court, in a case from 2014 called Maryland versus King, justified that type of search incident to an arrest, although they did it under a different exception, the so-called booking exception to the warrant requirement. But they found that it's minimally intrusive, no pain, takes just a couple seconds, and the utility from the evidence and compared to the minor intrusion on your body, there's just no comparison in terms of the value that evidence has, not only to law enforcement, but also to the judiciary as well. So in the Birchfield case, the court analogizes the minor inconvenience associated, the minor level of intrusion associated with the breath sample with the taking of the buccal swab, and found that it's appropriate under the Fourth Amendment as an exception to the warrant requirement for the search incident to an arrest. So far, so good? Okay. Now, what does this mean for New Jersey? Well, right off the bat, it changes New Jersey law fundamentally. The cops haven't figured this out yet, but when they do, look out. Because it now means, well, look, why do we give breath samples in New Jersey? It's because of the implied consent statute. There's a statute that you've impliedly consented to giving a sample of your breath when you get into the car with the intention of driving it. You agree?
I think that's the purpose of it, yeah.
I thought so too. So no matter how drunk you are, whether you can understand or not understand, it doesn't matter. You've already impliedly consented to giving your breath sample by getting into the car. Mm-hmm. Now, you have an affirmative obligation as part of a search incident to an arrest to give a breath sample once you've been arrested for drunk driving. Meaning that if you refuse to give a breath sample, not only could you be charged with a refusal, but you could also be charged with 2C29-1, hindering the administration of law. This gives the cops a whole lot more firepower, because not only is it a disorderly persons offense, but since you've utilized a motor vehicle in the commission of the offense, they could add an additional suspension of your driving privileges for up to another 2 years on top of everything else. So it gives the police, at least in New Jersey, some additional firepower, as I say, in terms of the enforcement of the refusal statute. They can really kind of jam you up bad if they wanted to, based on the Birchfield case. But besides that, I really want to kind of think outside the box in this case in terms of the impact of Birchfield on another aspect of drunk driving, which is the urine samples. Okay? And I want you to all think about analogizing the taking of a urine sample from a human being who's been arrested for drunk driving, and think about whether or not it's New Jersey law really is constitutional anymore. Joe made reference to the 1987 State versus Malik case earlier on, and Malik justified the taking of a urine sample from someone who's been arrested under two independent exceptions to the warrant requirement. A, search incident to an arrest, and B, exigent circumstances, okay? The police have to get this information because they need to get it right away. Kind of analogizing it to the loss of evidence in blood cases. Now, we'll come back to this in a second, but just remember that in blood, you're losing the evidence at 0.015% per hour after it's been completely absorbed into the body. Let's talk about the first part of this justification, search incident to an arrest, okay? Well, the Supreme Court has already ruled that there is no categorical right to take blood from everybody who's been arrested, okay? You got to get a search warrant or have exigent circumstances, okay? I would argue to you that the taking of a urine sample is every bit as intrusive, and not even more intrusive, than taking a urine sample from a person. You have a very high expectation of privacy in biological functions generally, and in urination in particular. There is a Bergen County case out of the appellate division called Solomon versus Kushner. And Solomon is spelled weird. It's like Soliman. This is a urination case. And the appellate division spends almost the entire opinion discussing your expectation of privacy with respect to urination. Okay? So your argument is, along the lines of Birchfield, that the intrusive nature of having to provide a urine sample, the fact that it is a search for evidence beneath the surface of the body, all these things militate in favor of you arguing that this prong of the Malik case has been overruled by the United States Supreme Court. Not only in Schmerber, which they never should have had it in the first place because of Schmerber, but by virtue of McNeely and by virtue of Birchfield. I don't think the Attorney General's office would really fight you too hard on that, Joe. Do you agree?
I agree.
All right. The second part deals with exigency. And my question to all of you is, at what point would you ever have exigency in a urine case? Can I borrow you for a second?
Sure.
Let's assume that you're an inveterate marijuana smoker.
Okay.
All right, but you're not particularly clever and the cops grab you. Okay? And 3 hours after you get arrested, they want a urine sample. And you're a nice guy and you give them the urine sample. Do you think that when the cops test your urine sample, it's going to test positive for the metabolites, the THC of marijuana?
Yes.
All right. Supposing the cops wait a day and take the urine sample the next day. Same sample. They send it out. Do you think the sample is going to come back positive?
Yes.
How about if they wait 3 days?
It'll come back positive.
All right. You guys
Is that from experience or you're just guessing?
I picked you for a reason. Look at that face. How could he possibly be guilty? Remember, in New Jersey... Oh, okay. I knew there had to be a reason. We're probably giving you some good stuff, too. In New Jersey, the state police protocol is they're just testing for presence or absence. They're not quantifying anything. Either you had the THC in your system or you didn't have the THC in your system. And they're doing this for any type of drug, urine screening. That's your experience, right, Joey?
Yeah, and it's interesting why they do that. In New Jersey, we do what we call a qualitative. That is it there or is it not? We don't care if it's 1 milligram per 100,000 or 1 milligram per 10 million, just whether it's present or not. And the reason I ultimately learned years later when I wondered about this was the following. There's no standard as to how much cocaine or how much marijuana, how much heroin needs to be in your blood before it affects your ability to drive. So even if we knew the amount, it means nothing. There's no published standards on that. So it's irrelevant why go through all the extra work when the numbers that come out would be meaningless.
So think about this logically. And I'm going to use a term here that has no scientific principle that you should think about. I'm just doing it to kind of make the point. Every drug that you take has a half-life associated with it in terms of how long it's going to show up in a urine sample taken from your body. But the fact that it's showing up in your urine has nothing to do with it being in your bloodstream affecting your judgment or ability to drive a car. It's leaching into your urine from the fat cells of your body. So different substances will have different, again, I use this incorrect scientific term, half-lives. So marijuana, fairly attenuated, maybe 2 weeks, a month, who knows, depending on how much you smoke and how often you smoke. Methamphetamine, heroin, methadone. I guess cocaine would probably be the shortest, at least that I know of.
Well, but then you have the rebound effect.
Right. But I mean, do you agree with me on this, Joe, just as a matter of science?
Oh, it is a matter of science. Although, even it just occurred to me as I was giving that answer a minute ago that how alcohol is easy. We have actually taken people to on a Sunday to a parking lot out in San Diego. They did this, and we gave them alcohol and measured their levels of alcohol and saw how well they could drive a marked course on an empty corporate parking lot, with cones on either side, and we could equate their ability to drive with a blood alcohol count. Now, we don't measure, the quantity of heroin, but how would you conduct that test? Bring people in, shoot a little heroin in, let them drive, shoot more heroin in, a few die, you realize, okay, that may be too
You'd have to go to Patterson to get the people, I know that much. The point I'm trying to make to all of you is, and really this is a rhetorical question, Joey, but when would you ever, especially in a marijuana case, have exigency associated in a drug case? When the evidence is going to be there for days. You mean the cops can't get a search warrant in 3 days? What's the rush? Why couldn't the cops get a search warrant?
Yeah, exigency does imply rush.
Right. So the point I'm trying to make for all of you guys is when you start looking at these urine cases that come into the office, you got to start asking yourself these questions when you file the motion to suppress. And you got to argue that Malik is not good law anymore for the reasons we talked about. Now, one additional thing I want to mention to you deals with consent. The Attorney General, who sees the handwriting on the wall, I think they have an idea where this is ultimately going to wind up, sent out a memorandum indicating that it's a good idea on these consent forms for urine samples to advise defendants about their rights under State versus Johnson, about the right to refuse to give consent, the voluntariness of the consent, and things of that nature. The argument you really need to raise is, well, the state can't have it both ways. So they say my guy was really messed up on drugs, that he could barely stand up. But by the same token, he was perfectly capable of giving his consent and waiving these important constitutional rights. You know, these are antithetical concepts. What you may want to do is look at the judge and say, well, Your Honor, let's figure out all the things you can do in New Jersey when you're drunk. Can you get a marriage license? No. Can you sign a contract? No. Can you close title to real estate? No. As a matter of fact, Judge, if you suspected my client standing here in front of you was pleading guilty that he was drunk or high on drugs, would you take his plea? No, you would not. No judge in New Jersey would take his plea because you want to make sure that the plea is voluntary and knowing. You may lock him up for the next 48 hours to make sure, you know, his head is clear when he comes back. But no judge is going to take a plea from an individual who's intoxicated because you recognize that there's no guarantee that he understands what he's waiving by pleading guilty. Okay? You think it's a good argument?
I think it's a great argument. Right. I mean, although you do have one benefit if you can't get a marriage license, you know, it gives you a chance to sober up and think really about it.
All right, so everybody cool with this? I want you to be able to take these cases and use them in your own practices for advocacy purposes. All right, now just for purposes of time, because AA is giving me the high sign here, we're going to kind of go a little bit faster through the rest of this stuff. I want to just mention to you about expectation of privacy and electronically stored records. You guys remember the controversy we had a few years ago where the National Security Agency got a hold of tens of millions of cell phone records and utilized their supercomputer to try to spot trends in terms of numbers that are called back and forth with each other? Do you guys remember that? You know, it was a very controversial thing at the time. And I think a lot of the controversy dealt with a misunderstanding by the public, and by that I mean 99.999% of the people in the United States, not realizing that under federal law you do not have an expectation of privacy in information that you voluntarily turn over to a third party. You just don't. All right? The public doesn't really kind of understand that, but the NSA did, and they were able to get all this information just through the expedient of using a subpoena. There was no judicial involvement in it all because since you have no expectation of privacy in this information, there's no Fourth Amendment issue implicated at all. The cops or the government can do whatever it wants. That is most decidedly not the law in New Jersey. Our Supreme Court, starting with the State versus Hunt case back in '82, has individually, with different types of records, continually provided expectations of privacy in electronic records that are turned over to a third party. It's the complete opposite of what federal law is. Now, there is no blanket expectation of privacy in New Jersey. They've done it on a case-by-case basis. And I've given you here a chronology. In case you have to read a brief, just copy this stuff, and this will be all the cases you're going to need. So we start off with State versus Hunt that I mentioned to you before, dealing with telephone records. Before the next case was published, it required a CDW, which is the functional equivalent of a search warrant. Mullica is really not good law anymore. Nobody uses hotel telephones to make calls anymore. But in that era, if the police wanted to get information related to telephone billing records, they would have to get a search warrant. McAllister deals with banking records, and the United States case is Miller, United States versus Miller, saying you have no expectation of privacy. In New Jersey, you do have an expectation of privacy in your banking records. There's McAllister. Domich, Joe's favorite case, he just likes the name, correct?
It's a great name.
Public utility records of using your heat, light, and power. You have an expectation of privacy. State versus Reed, internet subscriber information. You have an expectation of privacy. And in the most recent case, State versus Earls, dealing with pings out of your cell phone, where the cell phone providers can provide through triangulation the location of the cell phone. That information is, you have an expectation of privacy in that information. And they have to get a search warrant in order to get that. Now,
and by the exigent circumstances you get with triangulation are where you believe someone's been kidnapped, for instance.
Right.
You know, and it's emergency. You don't have time for a search warrant. You got to try to find that car with her cell phone and her person and track it down before she's whisked away and perhaps injured or killed.
It's very easy to envision something like that happening where the cops don't have time to get a warrant. Now, just because I've told you there's an expectation of privacy, that's fine, but there are varying expectations of privacy. Some records require more privacy than others. I think the highest one is this Earl's case where the police have to get a search warrant. To reflect the degree of privacy associated with these records, the court gives different levels of how the cops can get to the information, all right? Now, there are three basic ways that police get information that's in the hands of a third party, okay? Let's talk about them very quickly. First, search warrant. Search warrant is going to involve the police doing an affidavit of probable cause, getting all the information they've gathered up to that particular point, making a case for probable cause, appearing before a neutral and detached magistrate, having the magistrate consider it, and then getting consent from the magistrate to conduct the search with particularity within whatever the parameters are of the warrant. Okay?
Involving a not inconsiderable amount of typing time and drafting time and, and the time on the part of police officers.
All right. There's an interim level of a step, which is a criminal action order by the Superior Court. This requires going before a Superior Court judge and showing that you have a reasonable articulable suspicion to believe that there's information that will lead to the discovery of criminal activity in some records, okay? Now, again, we're not talking about probable cause here. We're talking about a lower standard than probable cause. It's just a reasonable articulable suspicion and some relevance to a criminal investigation. So there is some minimal level of judicial review here, but again, the standard is less than probable cause and does not require all the detail that a search warrant application would. The lowest form, requiring the least judicial intervention and the fewest standards, is the grand jury subpoena ducis tecum. All that is necessary there is for the grand jury to be satisfied that there's information which is relevant to some type of criminal investigation that the grand jury is looking at. The grand jury can then issue their own subpoena and can get that information. What you should see is that what the Supreme Court has done over the years is they've ascribed different levels of authority that's necessary to get these records. So in Hunt, for example, initially they said you had to have a search warrant. Mullica, search warrant. McAllister, dealing with banking records, it was sufficient to get a subpoena ducis tecum from the grand jury. Domich, subpoena ducis tecum from the grand jury. Same thing with State versus Reed. Earls, they kept the high standard of having to get a search warrant. What you're going to find now is in this Lunsford case, the court is going to step down and provide a lesser protection to telephone records. And a lot of this deals with the reality of people using multiple phones and utilizing cell phones and traveling and things of that nature. The court really wanted to make it easier for the police to get that information because it's impractical to get a search warrant in these types of cases. The investigations are way, way, way too fluid. So what the court is going to say is, in this Lunsford, cell phone tracking information may be obtained by the police through either a search warrant or by demonstrating exigent circumstances that excuse the police from getting a warrant. What they're doing now to change that is they're making reference to the New Jersey wiretap statute, which requires that only that they demonstrate reasonable grounds for believing the records sought are relevant and material to an ongoing criminal investigation. The police can go to a judge of the Superior Court with that information and get a criminal action order, which will require the provider to turn over those records. Okay? Now, that is the only one that they've changed, but it's significant. It really kind of overrules State versus Hunt in terms of the level that the police are going to need to get that telephone information. All right? Okay. Related is roving wiretaps. Again, this deals with the reality of current sophisticated criminal activity where criminals are utilizing multiple cell phones. They use these burners that they utilize. They'll make one call and throw it away. And when the police would go for a wiretap, the particularity clause of the Fourth Amendment and Article 1, Paragraph 7 of the state constitution requires that they say with particularity what phone number they're going to be listening to for how long and what they expect to find. Criminals are not going to wait around to have that happen. They're switching phones constantly. The wiretap statute, both state and federal, provide the ability to get something called a roving wiretap. And a roving wiretap allows the police to get a wiretap for a broad set of phones without specifying numbers or any information related to the specifics of those phones. In other words, it kind of excuses the particularity requirement of the Fourth Amendment and Article 1, Paragraph 7. This is the first time this has come up, and the New Jersey Supreme Court authorizes now the use of roving wiretaps for the first time with the following proviso, and it says right here, when the target purposely changed facilities to avoid detection, he creates an inherent exigency that important evidence will be lost. We therefore find law enforcement officers may switch over and begin to monitor a new facility, meaning a new telephone, under the state's wiretap law, provided they have otherwise fully complied with the statute. To avoid serious questions under the state constitution, we direct going forward, law enforcement must notify a wiretap judge within 48 hours of the switch and obtain authorization to continue monitoring the new facility. Okay? All right, on stop and frisk, we mentioned this before. Joe was talking about, and I had not heard of that study, Joey, about the...
it just came out this week. And, of course, it was, the police department poo-pooed it.
Joe and I do an enormous amount of teaching, as you guys know, all over the place. And one of the things that we stress, Joe especially stresses this, get people out of the habit of saying stop and frisk. It's not stop and frisk. It's stop and frisk if appropriate. The stop is predicated upon a reasonable and articulable suspicion. The frisk is also predicated upon a reasonable and articulable suspicion that the defendant has some type of weapon or something that could constitute a physical threat to the officer in his possession. So it's a limited search of the pat-down of the exterior clothing in order to recover that weapon, not evidence, but to remove weapons. The seminal case dealing with all these issues is State versus Thomas, which talks about this concept of both stopping and frisking, but again, no stop unless it's appropriate and no frisk unless it's appropriate. There has to be a reasonable and articulable suspicion supporting both parts of this. The cops don't understand that. They can just walk up to people on the street and start, frisking them, okay? This case is, it's just a classic example of the use of the totality of the circumstances test. It involves, what's the place where they have the Indians? Is it Mawa?
Yeah. All right. Mawa, what we call the Ramapo section.
All right, the Ramapo people. Okay. You guys know what I'm talking about? It's not the only place in New Jersey where they have wacky people. I mean, people that are not part of the United States are just out there. There's a place similar to that in Salem County, and they're hostile to the police. They don't want the police there. It's actually technically it's part of Kentucky. I don't know if you guys knew that or not. In any event, the state police were called to patrol the area because of this outrageous crime. The people said, we don't want you cops here. We're going to greet you with vandalism, sabotage, and gunfire if you try to come into our community. So the state police being justifiably concerned, did two-man patrols, not only in cars, but also on foot to protect the troopers. On this particular occasion, as one of these foot patrols, they encounter Mr. Bard, the defendant. They see him walking toward him in the nighttime, and they kind of greet him. They don't get any greeting back from him. When they see each other, he puts his hand in his back pocket. Now, these cops are on edge to begin with, and when they see him put his hand in his pocket and they tell him to take his hand out of his pocket and he doesn't do it immediately, now the police are really on edge, okay? They grab his hand out of there, they pat him down, they feel what they think is drug contraband, remove it and arrest him, okay? So, did the police act reasonably in detaining him and then conducting this search? Well, under the totality of the circumstances model, judges are not supposed to cherry pick one or two facts in isolation. You look at everything, all the factors confronting the police, because many times when you consider all the factors, it paints a mosaic of guilt. All right, take a look at what they say here. The officers became alarmed. They faced grave danger by the encounter, including the defendant's hand movement toward and into his back pocket, disregard when he was told to show his concealed hand. Troopers' personal knowledge of the numerous violent crimes occurring in the neighborhood, warnings regarding police safety, the hour of the day, lack of lighting, troopers' training experience, fear of exposure to dangers was rationally drawn, making the troopers stop at the defendant not only objectively reasonable, but necessary to assure the troopers' safety. So there was a reasonable and articulable suspicion to detain him for investigative purposes initially, and then a secondary one to conduct this pat-down of this individual, which led in a plain field type situation to the recovery of the evidence, okay? The main takeaway, I think, for you guys, apart from the stop and frisk component, is the totality of the circumstances analysis. Very important. Cushing, it was a surprising case to me as it was a third-party doctrine case. And by that I mean, who has the authority in the search of a private home to let the cops come in and conduct a search, all right? Let me give you this setup. There's a young boy. I'm trying to remember the legal term for this. He's been living with his grandmother. He's 26. He's been living with his grandmother since he was 8. He's unemployed and just hangs out all day. although he has recently had his whore girlfriend move in with him. What's the legal term for somebody like that? Do you remember? Bum! That's it. He's a bum. All right. But his grandmother lets him stay there because I guess she's used to him by now. All right. Now this arrangement creates a lot of dissension in the family, particularly among the children of the grandmother, who doesn't want this bum living in the house, especially with the girl. So the daughter of the grandmother, his aunt, the bum's aunt, comes to the house one day and says, I'm going to put a stop to this sinfulness. She goes into his room, and what does she see in there? The guy's got a marijuana farm growing, all right? So she says, oh, I'm going to take care of this guy right now. She goes outside, she calls the police, and the police come over. And she stops and she says to the cops, listen, I went in there a few minutes ago, and I saw lights, I saw marijuana growing, I saw this, this, and this, all right? It gives them a complete history of what she saw. Now, stop and think about this as lawyers. At this point, the cops have all they need to get a search warrant, okay? Doesn't take a whole lot to get probable cause. We're not talking about a whole bunch of evidence here. He's got enough evidence to get a search warrant here, okay? You're going to see that that's why the collateral source rule is in play here. He has information from a collateral source that does not involve any violation of the Constitution at all to get a search warrant right now. But does he do that? Of course not. We wouldn't have had a case otherwise.
No,
right?
no, it wouldn't have been reported.
She says, come on in, I want to show you. So the officer, before he goes in, he says, well, who are you? This is my mother that owns the house. Okay, where's your mother? Well, she's not here now, but I have power of attorney, so you can come with me. Power of attorney, right?
Power of attorney, she said that with magic words.
So here they go. The cop goes in, he sees all the marijuana, he says, yep, there's a whole bunch of marijuana growing here. All right, let's go out. He goes outside, calls his bosses, and they start the process now to get a search warrant for the house, all right? While they're waiting around for the search warrant, the grandmother comes back to the house, and the cops say, maybe we can speed this whole process up. Hey, Grandma, can we have your permission, consent to go in and search the house? And the grandmother says, yeah, sure, you can go in and search the house, but just don't go into my grandson's room, okay? That's his room. I just whatever goes on in there, that's his business. I stay out of there. So the cops say, all right. So they go, they search the whole house, find nothing. They don't go into the room where the grandson lives, because there's no reason for them to at this point. So the search yields nothing, but this is very important evidence because it shows that the grandmother determined that this adult child, so to speak, had an expectation of privacy in the room which she expected. So here's the takeaway in this case. They're going to wind up suppressing this evidence. Why? Because this woman who said she had the power of attorney, she didn't have authority over this house, and she certainly didn't have any authority to have the police go into this particular room. An adult child living in a house has an expectation of privacy, generally speaking, in his living quarters. Not the same with children. That's the mom exception to the Fourth Amendment, okay? But for adult children, if the family recognizes an expectation of privacy in the room, then it has to be respected. The fact that she had a power of attorney is meaningless. If you sign a power of attorney over to somebody, you can't give that person powers that you yourself don't already have. The grandmother acknowledged herself that she didn't have the power to go into the room because the guy had an expectation of privacy.
What is WL?
Westlaw. Yeah, it was too new. I didn't have the site. So this is the Westlaw site. Oh, yes, ma'am.
But didn't they get a search warrant?
They got a search warrant later on, but I mean, they found the information. He wound up getting it suppressed because
the information in the search warrant affidavit was illegally obtained.
But what happened is, because he had mentioned about the going in and seeing the stuff in the warrant application. But here's the point I'm trying to make. This is why this gets remanded back to the trial court, because they say you might have a perfectly good collateral source rule here, because you had enough information to get the search warrant without seeing that stuff in the first place. I think there might be a good mistake of law case here as well. I mean, the police officer, he questioned this person. He was just wrong as a matter of law. He thought because she had a power of attorney that gave her kind of general authority.
There is no valid mistake of law in New Jersey.
That's true.
and until we decide Sutherland, you're to stop saying that.
The next two cases are related to each other. And Joe, you were telling me about a case that was reminding me of this a few minutes ago. Bailey versus the United States is what's in play here. And this is a case that stands for the following proposition, that when the police execute a search warrant, if there are people who leave the scene of the search warrant, the cops have no right under the search warrant to grab these people, detain them, and bring them back. The only people that can be detained during the execution of a search warrant are people who are at the scene of the execution of the search warrant. Now, in the Watts case, here's what happens. The cops have a warrant to search this guy's apartment, okay? But it's an interesting search warrant. It says you can go in there and search the apartment. It's a no-knock warrant, by the way. And you can also search Mr. Watts, who will no doubt have all kinds of evidence on his person. So the cops have two things. They can search the house and Mr. Watt. He's actually named in the search warrant. So the cops are getting themselves ready to go. They see Mr. Watts come out of his apartment and leave the area on foot, okay? The police says, oh, we can't let this guy go. Plus, he might have a key to the apartment. We can avoid breaking the door down. So the police grab him, detain him, do a preliminary search just to make sure he doesn't have any weapons in his possession, handcuff him, and take him back to the scene. The intention of the police to get him back there, take him inside, and then search him in conformity with the search warrant in a much more thorough way. When they get him out of the car, they look on the floor, and they find he's discarded all kinds of drugs in the car, while he's handcuffed, by the way, in the short ride between where they got him on the street and brought him back.
And the police turned in over half those drugs, so they were very honest.
Yes. And some of the money, too. Did the police act reasonably in stopping him? Answer, yes. The police had authority to search him under the warrant, and they acted reasonably in respecting his dignity by not doing a body cavity strip search out on the street. Rather, they took him back and conducted the search in private. All told, this is not a Bailey case because the police had judicial authority to grab this guy and search him, as opposed to the Bailey case where there's just people that were not even named in the warrant. They just happened to be there. Now, the related case for Watts is Bivens. And Bivens is it's here's how this case works out. Here's the warrant in Bivens. Hey, cops, break the door down and search the house. And oh, by the way, search every single person you find in that house. Because the only reason they would be in the house is because they have evidence in their possession. Okay? Sounds like the typical drug case. But the name of this type of a warrant is an all persons present warrant. Okay? Now, again, you think about the particularity clause of the state and federal constitutions. It's not saying with particularity who those people are and what type of drugs they're going to have in their possession, because the cops generally don't know. It's just that everybody's in the house. The only reason they would be in the house is because they're guilty. I mean, that's really the philosophy behind this. The first time this came up was in the context of a case called State versus DeSimone, where the New Jersey Supreme Court authorized this type of a case. Now, the evidence is going to be suppressed in this case because of bungling by the state. And this is a close case, so I want to kind of just give you the facts real fast. So there's a trooper who's there for security purposes about 2 blocks away from where the search warrant's going to be executed, okay? And the cops, as usual, are loaded for bear, you know. He gets a radio broadcast from a fellow trooper. Hey, there's 2 guys driving towards your position who just came out of the house. They're in a gray Pontiac. Stop them and bring them back here. Okay? A couple seconds later, he sees a gray Pontiac with 2 guys inside of it. So he stops the car, yanks them out, searches them, finds drugs, arrests them, brings them back. Okay? So now we're at the motion to suppress evidence. And the only person who testifies is the trooper who says, I got this radio call, I saw a car a couple seconds later, gray Pontiac, 2 guys are inside, I stopped them, arrested them, found drugs on them. Okay? Supreme Court says, oh yeah? How do you know those were the same 2 guys at the house? The assistant prosecutor argued, well, it had to be. Who else could it be? And the Supreme Court says, well, you know, we don't know. Why didn't you call the trooper who saw those 2 guys leave? And then we would know by clear and convincing evidence that the 2 guys that the first trooper saw leave are the same 2 guys that were stopped by the second trooper. We don't have that here. You never called the first trooper to say that these are the 2 guys that he actually saw. Maybe it was 2 other guys by coincidence in a gray Pontiac. All right? But I mean, think about it logically, it makes sense. I can't imagine this happening anywhere but the Supreme Court. I think, municipal court, forget about it.
Oh, okay. Are you kidding me? I've been fighting this exact fact pattern for 2 years now, where the police had a search warrant for a house. But before they served it, they were surveilling the house. They saw my client and someone else leave the house, get in a car, and drive away. About 15 minutes later, they go in and execute the search warrant, but they radio their buddies, pull over that car on the basis of suspicion, because they just left the house. Mm-hmm. So they do. And then the question became, where do I litigate that motion to suppress? I said they were pulled over for no justifiable reason. Right. Suspicion of what? Leaving a house? Yeah. Where, by the way, there was a person who was a schoolmate of my client, okay? And The municipal court refused to hear it. They said, no, that's pursuant to a warrant. I said, no, it's not pursuant to a warrant. They weren't there. They left 15 minutes earlier. So we went up to the Superior Court, and after 6 months, they said, no, this had nothing to do with the warrant. Go litigate it below. And it's been pending now for 8 months down below.
That's a total winner, Judge, on the Joe, on the Bailey case. And there's a New Jersey equivalent to Bailey, which says the same thing. I'll send to you this afternoon.
Oh, no, but I can't get anyone in the municipal court to agree. They said, no, they left the house where they later executed a search warrant. I said, that's my point,
Cope is an important case. It's finally an explanation of the limitations of the protective sweep exception to the warrant requirement. A protective sweep comes out of Maryland versus Bowie. It is a categorical right that the police have when they go into a residence to serve an arrest warrant. They have a categorical right to conduct a quick sweep of the area and the rooms on the floor where the defendant is being arrested in order to intercept any person there who's hiding who could constitute a threat to them, produce a weapon, or otherwise try to either thwart or interfere with the arrest. Now, what happens typically is when the police are conducting this sweep, they find evidence, guns, drugs, and things of that nature in plain view, okay? But I want you to all understand that it's a categorical right that the police have. No reasonable suspicion or anything like that is required when you're serving a warrant. Unfortunately for us, in New Jersey, the initial case interpreting this is a case called State versus Davila. Davila did not involve serving an arrest warrant. It involved police who were supposedly brought in, who were there to interview somebody, a person of interest, so to speak, inside of an apartment. And I think the problem with the Davila case is the Supreme Court just didn't believe the story that the police were telling. And they set forth rules for New Jersey when the police want to conduct a sweep of a residence where they're there for a purpose other than serving a warrant, okay? And it's a very poorly written, confusing decision. Cope, I think, is their effort now to clarify the law. Cope actually involves the serving of an arrest warrant, okay? And the police have the place staked out. The guy lives on a second-floor apartment. He has a balcony in his apartment. And before the police serve the warrant, they see him out on the balcony. Knock on the door, can we come in? Joe Schmo, you're under arrest. The police, while they're cuffing him and Mirandizing him, start doing a sweep, and they go out onto this balcony, which is close to where he was arrested, and they recover a rifle on the balcony. And Mr. Cope is a certain person, okay? Very bad for him. So it's a plain view recovery of the weapon. Now what's good is that the Supreme Court here, finally, New Jersey Supreme Court, sets forth the rules you're supposed to follow in New Jersey for protective sweep. And here it is. Protective sweep an in-house arrest is permissible under the following circumstances. Police may sweep the spaces immediately adjoining the place of arrest from which an attack might be launched, even in the absence of probable cause or reasonable suspicion. Again, it's categorical. Any wider sweep must be justified by specific facts that would cause a reasonable officer to believe there's a person within the premises who poses a danger to arresting officers. So you want to go to the second floor, you want to go to the basement and do a sweep, you got to have a reasonable suspicion. The sweep must be narrowly confined to a cursory visual inspection of those places from which a person might be hiding. So you shouldn't be looking in any dresser drawers unless you're looking for Mickey Rooney. Although the sweep is not a search for weapons or contraband, such items may be seized if observed in plain view. Last, the sweep should last no longer than necessary to dispel the reasonable suspicion of danger or complete the arrest and depart the premises. Okay? So good explanation now, finally, of what the protective sweep exception is under New Jersey law. Whew. How do we do for time, AA?
We're a bit over.
A bit? Oh, I'm sorry. Okay, we won't talk as much.
In fact, second one's now over.
Do you guys have a good time or a bad time? Was this helpful to you? As always, thank you. Joe and I want this to be practical. We want you to be able to take the information you learn here and utilize it in advocacy in your own cases, either as prosecutors or defense. And use the materials you have here so it'll be helpful to write your briefs.